We are live.
All right, thank you. This is Senate Judiciary. It's March 23rd. We have H41 on the agenda, and we're going to be hearing from Sarah Robinson first from the Vermont Network.
Good morning. Good to be with you all. Sarah Robinson, Deputy Director at the Vermont Network Against Domestic and Sexual Violence. Thank you so much for the opportunity to speak with the committee today about H41. And from our perspective, this bill really represents an overdue revisit to questions about the role for restorative justice for victims of domestic and sexual violence. I thought I would start with just a little bit of history and context in terms of, from our perspective, where this proposal comes from. In 2007, the community justice centers were first codified in state statute. And at that time, really formalized restorative justice practices were first emerging in an organized way throughout Vermont. And community justice centers also had a narrower scope. Their primary work was kind of lower level reparative boards for lower level offenses. And at that time, the network, and I would say broadly, the victim services movement across the country was really uncertain of restorative justice approaches and the ability of those programs to truly hold offenders accountable and to provide victim safety in the context of those processes. And as the community justice centers were being codified in statute, it was actually the Vermont Network that requested the authorizing statute that the authorizing statute for community justice centers include a prohibition on referring domestic violence, sexual violence, and stalking cases to the CJCs. So today we come to you after many years of evolution in both our thinking and in restorative justice processes, and to ask you to really create a careful exception to this prohibition that will center victim safety. So since 2007, there has been this thoughtful and important evolution, both in the victim services field and in the thinking and practices related to restorative justice. There's certainly broad acknowledgement that the tools that are offered by the criminal legal system are very important, and the safety provided by those tools are very important. But all too often, those responses can also be further traumatizing to victims or leave survivors lacking a sense of resolution, justice, or healing. Also, our current legal responses are often designed around survivors who report to the legal system or those who seek separation from the person who caused them harm. And there remains a significant gap in community responses for victims who do not report or those who choose to remain in relationship with their partners. The majority of survivors of domestic and sexual violence never report their experience to the legal system. National data would suggest that about half of domestic violence survivors ever report, and only a quarter of sexual violence survivors ever report. And just by way of note, to bring that home, here in Vermont in 2021, about 8,000 our member organizations, the 15 organizations that provide direct services to victims of domestic and sexual violence across the state, provided in-person support to about 8,000 Vermonters. And in that same year, there were only 400 prosecutions for domestic violence. So you'll see that there's a really significant gap between those who identify as experiencing domestic or sexual violence and those that our criminal or legal system are really designed to provide some kind of solution to. As the understandings of kind of the limitations of these legal processes have evolved, so too have explorations of restorative justice in these contexts. In 2018, the legislature passed Act 146, and that created an interdisciplinary study committee which examined the potentials for restorative justice for victims of domestic violence, sexual violence, and stalking. The committee met for a year and issued an interim and final report with consensus recommendations, and those recommendations really comprise the foundation of the proposal that you're contemplating today. I have also submitted the final report of Act 146 to Peggy to be posted on the committee's website. And the practices of community justice centers have continued to expand as well, and I'm sure you'll hear more about that from Rachel. One example is that the Hartford Community Justice Center, in partnership with their local member victim services organization, established Circles of Peace, which is a restorative justice program specifically for individuals charged with misdemeanor domestic violence. They were able to do this kind of through a statutory workaround by becoming a domestic violence accountability program. And on the national level, there's also been examination of these approaches and their efficacy. In 2019, the National Center for Justice Innovation was funded by the Department of Justice to actually catalog the current use of restorative justice in intimate partner violence, and they issued a report also posted on your website. And most recently in 2022, Congress reauthorized the Violence Against Women Act, which is the primary legislation which addresses violence against women in the United States, and for the first time created a grant program through the Violence Against Women Act specifically to fund restorative practices aimed at addressing intimate partner violence. So combined, all of these efforts really demonstrate that restorative approaches for victims of domestic and sexual violence are not a replacement, but a complement to our current legal approaches, and that those approaches have come fully into the mainstream. So the proposal that's being considered by the committee today is a small and very narrow step towards creating a safe and thoughtful approach to creating restorative justice options for victims. The bill, as it was originally introduced in the House, was the result of months of discussions between the 15-member organizations of the Vermont Network Against Domestic and Sexual Violence and the 17 community justice centers across the state. As the House considered this bill, important improvements were made at the recommendation of many stakeholders. And I want to highlight just a few important facets of the bill that you're considering. First, the bill actually maintains the prohibition on domestic violence, sexual violence, and stalking cases being referred to community justice centers, but it creates an exception to the prohibition if a robust set of preconditions are satisfied. So nothing in the language requires communities to develop such programming. It simply creates a framework for the process to occur if there's readiness, interest, and capacity within the community. It creates an important balance between community ownership of restorative justice approaches and statewide oversight and accountability. The heart of this framework relies on memorandums of understanding between community justice centers and local domestic and sexual violence services organizations. And it also creates an important oversight role for the Community Justice Unit at the Attorney General's office, which will work with the network, the Vermont Center for Crime Victim Services, and others to establish statewide practice guidance and ensure that those local MOUs are compliant with statute. They'll also collect data and report back to the legislature. And I want to highlight just two other brief points. In accordance with the Department of Corrections stated wishes, they are one funder of many community justice centers. We're in agreement with them that the grant funding that's routinely dispersed to community justice centers will not be used for these specific purposes. There's not an appropriation that's associated with this request. As I mentioned before, we anticipate a federal grant program from the Department of Justice becoming available in the coming year to support these efforts, and we'll continue to work with CJCs to seek additional and new funding for this use. And finally, I just wanted to note that victim-centered restorative justice can occur at any point along, what we often refer to as the sequential intercept model. So that's the model that we kind of visualize how a person might move through the legal system. So that could be a restorative justice intervention that happens at the pre-reporting stage for a victim or survivor who are not going to report, all the way through to re-entry. And depending on the model that a community chooses, there are going to be various stakeholders involved in that model. So a lot of the restorative justice that you may be most familiar with is related to referrals that might come directly from either a police department or a prosecutor's office. That is just one particular model, but there are models across the country and in fact across the world where restorative justice happens in ways that sometimes include both parties, and sometimes for truly centered restorative, victim-centered restorative approaches may also just include a victim. So we appreciate your consideration today. I'd be happy to answer any questions that you might have as after your walkthrough from Attorney Childs yesterday, or anything else I could answer for you.
So, Sarah, I have a question regarding, community justice centers, the victim in the case has to, and correct me if I'm wrong, but the victim has to grant consent for the defendant to also go through it, like they have to agree to that, right?
Yes, so as outlined in both the statute and will be outlined in the practice guidance from the Attorney General's office, it requires voluntary participation by all parties.
Okay, and so I think I support the idea in general, and I'm always for new ways to avoid going through the criminal justice system. But one of my concerns has to do with just the nature of domestic violence itself, and having a victim who, well, let's say, for example, in court, victims often redact their statements, and because they're still stuck in that nexus of domestic violence. And so I worry about victims who might be getting manipulated by their abuser to say, I want the abuser, or I want the defendant to come through the community justice system instead of the criminal justice system. So I was wondering if you have any thoughts on that.
It's a great question. And you're absolutely right to highlight that control and coercion is a primary element of intimate partner violence. You're also, I think, right to highlight that already exists. And that kind of coercion is already exists kind of within our existing legal responses, right? So what I would say is that this proposal creates a robust set of preconditions, including training for all of, for everyone who's involved, any CJCs, domestic and sexual violence organizations, any volunteers, all the stakeholders, that they're going to have actually really detailed policies and protocols about what voluntary engagement looks like and how they're able to determine that voluntary engagement exists. And I would say that honestly, those are safeguards that don't exist right now in our system. So in many ways, I think that we feel confident that this creates some important safeguards to address specifically the dynamics that you were referring to, but that we feel very comfortable with where the language is. And I'll also just note that one of the reasons survivors may decline to participate in a criminal process has to do with the outcome of that criminal process having really negative impacts on the survivor themselves or their children. And so in truly victim-centered approaches allow survivors to make those decisions. And most survivors truly want violence to stop in their lives. They're not always seeking what you might, think of as like retributive punishment. And so this is not going to be necessarily the option that is either safest or of interest to many survivors, but for those that do want an option, especially those who don't believe that the criminal legal system is an option for them, we think that there ought to be something else, some other way for them to address the harm and to receive the support of their community.
Thank you.
Yeah.
Any questions?
Yeah, I just got a quick one, and it really has nothing to do with. I was curious about the MOU. So,
Yeah.
Is there a template that's going to be used statewide, or is that something you're supposed to look at? Or?
Yeah, that is exactly what the Attorney General's office is going to be doing. So I'm just going to pull up the place in the statute. One second. So you'll see that, the Attorney General's office is tasked with providing essentially technical assistance to the community justice centers. And there are going to be statewide practice guidance that is developed by the community justice unit. And then they will essentially review each of those MOUs to ensure that they comply. So the top of page 4, bottom of page 3, top of page 4. So on or before July 1 of next year, the AG's office, in consultation with the network and the Center for Crime Victim Services, shall create guidance for memorandums of understanding. So the idea is for there to be exactly that, a template for communities to use, guidance about the requirements of those memorandums of understanding so that communities can go ahead and develop those in a way that complies with the law.
Okay, thank you.
Yep. The only other thing I'll say is I think I heard in the walkthrough yesterday there being some question about the reports. And I'm sure you'll hear from other witnesses on that. The bill as it was introduced did not have any reports in it. That was really the result of stakeholder feedback and input. And the idea being that these are newer approaches that are going to be addressed, that are going to be moved forward in communities across Vermont. And there was certainly, I would say, widespread support for there being some process for communities to report back to the legislature to understand the efficacy and impact of these approaches. Any questions?
No, I don't think so. Thank you.
Thank you very much.
Great. And Rachel?
Thank you for having me. I apologize for my lateness, and it's actually, I think, a favor for you that Sarah went first. She has the most broad and comprehensive overview. For the record, my name is Rachel Jolly. I lead the Burlington Community Justice Center, and today I'm speaking on behalf of the 17 community justice centers in Vermont. Just to clarify, those 17 CJCs, we're part of a network of 24 state-funded RJ organizations, but these 17 CJCs all do get funding from the Department of Corrections. But as Sarah mentioned, this would not be included as part of our DOC contract, but we share a common history and funding currently, as well as a lot of our programming and interests around creating more options for survivors. So I think we'll be underscoring the majority, like many of Sarah's points. I don't really have that much new to add because it was such a collaborative process. As Sarah mentioned, this was the result of many months of discussions with member organizations and CJCs. Our main motivation was to provide more options for survivors than going through the traditional system. So again, this is not instead of necessarily, it's just adding options. Community justice is part of the criminal justice reform movement, and criminal justice reform does not ask us to move in the direction of either or thinking. It asks us to acknowledge nuance and develop options that expand notions of accountability. And it's beyond punishment and providing authentic choices for victims and survivors that recognize the enormous variety in their experience. And as Sarah mentioned, that report in 2018 and 19, the Act 146 process, I sat on that group exploring the possibilities of domestic and sexual violence and restorative justice, which included a survey of focus groups with over 160 DV, SV, and stalking survivors. Some themes that emerged from that: a strong majority expressed disappointment with the current system responses. Survivors identified interest in attempting repair and/or reparation at multiple points in their process, and of their interest in expanding the notion of accountability beyond what is used in the criminal justice system. Survivors wondered where there could be multiple entry points to one larger, quote, system of justice, which included criminal, community, family, and healing-based justice options. So again, survivors were they did ask for and deserve more options than our criminal legal system provides. The majority of the survivors aren't using the system currently, as Sarah also highlighted. So this bill asks us to take first many steps. It's really just a beginning of a journey to crack open this door around the exception, to start exploring what that could look like, knowing that really we would need to step out of any current templates or processes that we currently use, including the training of our volunteers, the training of our staff, the partnerships that we're looking to. We're really not looking to just add a population to our current processes, we're looking at exploring whole new processes. And that's one of the advantages of this MOU that looks to national and international models that we know already exist and can learn from. And I do want to highlight two things, which is these restorative processes are nothing new. This is, contemporary movement to add it to their criminal mainstream legal system. It kind of arose in the 70s and 80s, but indigenous populations throughout the world have been using restorative processes or that holistic kind of thinking with a lot of the same principles for millennia around resolving disputes and looking at a more holistic picture of the conflicts going on. And we, in our contemporary movement, are already seeing these kinds of cases, maybe not formally in terms of DV and SV being the charge, but we know for sure that these behaviors and conditions are happening in the background of charges that we do formally receive, as well as I would say the Department for Children and Families Balanced and Restorative Justice Program does allow DV and SV cases to come to CJCs. So our CJC is receiving DV and SV cases, and we know that so much more work is involved to position ourselves to be ready to accept these properly and deal with them in a responsible, safe way. And so we're already, I think, doing some of the work that will position us well if and when this isn't allowed. But underscoring another point that Sarah made, this is not an either or process. That this would allow cases perhaps to come through the criminal legal system, but it also would expand those options for it coming out. For all of those reasons, the CJCs are in support of the current bill as written. And I will say too, I think the process has been a healthy one in terms of the additions that were made in the House around the AGO's Community Justice Unit oversight, as well as more parameters around confidentiality.
So I just have one question. So I'll just preface again by saying I do support this, but I also like to try thinking about the other angles that folks might come at regarding this and what some other people's concerns might be. And one thing that I hear a lot about is accountability. And I think that when folks who may not be familiar with community justice centers, when they hear about the restorative aspect of it, they also will want to know, well, what about the accountability aspect of it for the person who committed the crime? So I was wondering if you could touch on that a little bit.
Sure. Yeah, I think that's a huge theme in what we do. One of the key principles of restorative processes is around accountability. I think the main tension point is for many people who grew up in this country or who came here recently, sometimes the definition of accountability equals punishment. And that's what restorative justice does question and does not equate those two things. So accountability includes taking responsibility for one's actions, looking at impact, and hearing from a more holistic view of that, where that impact is. In our current system, that's generally the state is the other party in that equation, the state versus Jane Smith. And that's where the accountability is looked at. Sometimes a victim impact statement might be included, but generally the voice of the victim is not included in that impact and therefore the accountability. So oftentimes responsible parties do not have to talk about what they do. They certainly don't have to face the victim or the survivor in that equation if they don't choose to. And sometimes, in other cases beyond DV and SV, sometimes paying a fine for somebody with means is no form of accountability at all. It may not really change anything, any way they look at the situation. So I think it's important to step back and ask what our current systems of accountability ask of our responsible parties and of our community, frankly. Restorative justice, that is a whole different paradigm. And so I would invite anybody who just has questions about that, curiosity, to go to an arraignment hearing and go to a trial, observe that in terms of what's asked of the responsible party, and then go to a restorative process and see the many steps that are involved in that kind of collaborative process that does ask for a collaborative agreement around what would create repair and what could help make things right around the relationship. Because again, restorative justice sees crime as a violation of relationships and asks who is impacted and what are their needs and whose obligation is it to meet those needs. So It's hard to say, there's no template response for what accountability is going to look like in these various situations. But for many survivors of domestic violence, they actually do want to stay in the relationship. They just want the abuse to stop. So sometimes that's going to be a long road of many months of negotiation in terms of even the preparation for the victim or survivor in terms of their process of what are they looking for repair. That sometimes is a long process, and sometimes they don't know when asked right at the beginning. So again, the long road to this is funding. It's connected to funding because we know it's not going to be a few months necessarily as some of our current processes take. This could be many months of preparation with both parties.
Thank you.
Mm-hmm.
All right, I don't think there's any other questions, so thank you for your
having me.
testimony. Yeah.
Yeah.
So next we have Jennifer.
Good morning. For the record, Jennifer Pullman with the Vermont Center for Crime Victim Services. I had planned on being there in person, but my 3 children and my dog had different plans for my day. So I appreciate the opportunity to participate virtually. With respect to the bill, we are in support of the bill that's before you, but the bill has certainly taken a journey, whereas with respect to the original bill, there was a divide in the advocate community, wherein most of the advocates that outside of the network that I was speaking with really had serious concerns about what this might mean. This has been a prohibition that's been in place for 15 years, and for many of them, it felt concerning. And when I say the advocates I speak with, it's, I'm in touch with the state's attorneys, with their advocates, hearing from police advocates, hearing from the advocate at the Attorney General's, hearing from the SIU directors who I used to work with closely. So there was a lot of concern. But I want to say that I say that only because where we are now, there's a lot more consensus, and we feel really good about where the bill is in terms of how it lies right now. They feel much more comfortable with it, and in terms of how the guardrails have been established and how there does feel like this is a little bit more of providing a little bit more of a structure. And part of it's been a journey for me too, because back when this was put in place, I was in a different role at the center, but we worked in lockstep with the network at that point in time to say, wow, this is really new. Restorative justice is really new. And we don't feel comfortable with DV cases and stalking cases going this route right now. We need to learn more. And we have learned more. Certainly I couldn't agree with Sarah more. There are many reasons why victims and survivors do not report. And that's a population of folks that we haven't figured out how to serve in a better way. So to have that victim-centered alternative option, or maybe it's a parallel option, really feels important. We're talking about people that have distrusted the system, feel marginalized and don't want to engage, have shame, and are fearful. And maybe they just want to know why it happened and they don't want it to happen again. And I speak from a personal perspective in that regard, in that I chose a restorative process myself a couple of decades ago, because I didn't want to report. I just wanted to know why, and I wanted to make sure it wouldn't happen again. And I walked into a situation where I thought I knew the parameters, and I thought I could trust the person who arranged it. And instead, I walked out feeling worse. So my concern is that if we're going to do this, that we do it right. And that's always been the center's concern, is that making sure that we have the guardrails up. It's never going to be perfect, but making sure that we are thinking about this in a deliberative manner. And again, I think that this bill right now illustrates what can happen when there's conversation amongst the stakeholders and can create a more solid approach. And so I really think this is exemplative in terms of what we can do when we have these conversations. One of our issues was the oversight issue that was addressed. We were so grateful to the AG's office for stepping in and providing that sort of general oversight that can provide that accountability that only a state agency really can do. And And we will be helping to, with the AG's office and with the network, to develop program standards, which we learned that unfortunately, the question came up is, what is a CJC? And unfortunately, there really isn't this, oversight agency that helps define, like, what does a CJC mean when you say you're a CJC? So the center already is charged in current statute with having to define and develop victim safety standards. So we'll be working in conjunction with the AG's office and the network to try and develop some consistency. We think about geographical justice and what that means. And I think it's important to think about, again, what does it mean when you say you are a CJC? We were pleased that there was improvement in terms of making sure that the state's attorneys are involved. If there's a criminal justice process that's also ongoing, and by involved, I mean helping to be a part of those MOUs in those cases. The confidentiality and privacy and mandated reporter pieces were really cleaned up. And so, those are pieces that were, again, developed through consensus work. And then finally, the piece that's really important to us is that there remain this obligation that we all report back. This question I know came up in committee yesterday as to whether this is necessary. And I know the center, as well as other stakeholders, do feel it is. And it's simply because, again, we are going down an unknown road. We have had this in place for 15 years. And as testimony, went through the House, and we learned that there were still so many questions. There, it was said, I said it, and I know devil's in the details on this. And questions were raised as to, what is funding going to look like? I know that there's a federal grant out there that the network is looking to pursue. We don't know what's going to happen with that. Organizational capacity. How do we do this right? Certainly, Rachel has an amazing CJC in Burlington. Hartford does as well. But not every CJC has that built-in organizational capacity. So it's really to explore what is actually needed to actually do this right. Our feeling, and I know that we share this, that others share this feeling, is that there needs to be one person who's reaching out to victims. It needs to be their person. They need to walk in the door and know that that's their person. So having victim liaisons is critical. The Center for Crime Victim Services funds 6 different victim liaisons through VOCA funding. But that leaves, when you have 17 programs, that leaves 11 other programs that don't have that person in place. So that's another piece that feels really significant to us as we go down this road and explore how we do this right. As far as, again, this other piece about reporting back, currently there are, as I mentioned, no consistent standards across the state for what it means when you call yourself a CJC. And I think that would be, again, important for the legislature to make sure that they know about that. You've been very deliberate and intentional when you created the statute, created this option, and it feels it would be really important for you to have that check-in. What are you coming up with in the field as far as what the standards are? And then the other piece that feels really important is just assessing the training needs. What is this going to look like? So it felt really important to us that there be a report back, a check-in, so that you all can understand what we're doing in the field if this were to go through, to make sure that the guardrails are as strong as possible as we go down a very different but really important road for victims and survivors. How can we engage more individuals in a practice that's restorative? How can we create opportunities for victims to define their own justice, but how can we do that in a very safe way? So for us, the report is really, really critical. And I think that another piece that you had raised, Senator Hashim, that also was really one that concerned us in House Judiciary and many stakeholders, was how do we assess that voluntariness piece? And I know that you probably will hear from Tim Leaders-Dumont on this as a prosecutor himself, but that's another piece that we think really needs to be fleshed out as well, because as you identified, and as Sarah agreed with, of course, that control dynamic, how do we assess that? And I think that's something that we can suss out through this process and could be a part of that report back. So I think there've been many questions raised. I think the commitment is there to answer those questions, and I really would encourage this committee to please keep in that report back provision so that we can inform you and we can make sure that we do our due diligence to answer some of these questions.
Thank you, Jennifer. Any questions from you guys? Great, thank you.
Thank you.
We have about 40 minutes until the next topic, and you have the Defender General in the room. Did you want to chime in on this, Mark?
I sure can.
Sounds good.
Excuse me, good morning, Marshall Paul from the Office of the Defender General. I'm a little not quite as prepared as I normally would be to testify on this, but I think I am ready to go. We did testify very favorably about this bill in the House. We're very supportive of this bill, and from our perspective, the most important part of this bill is that it addresses what are currently unreported cases of sexual and domestic violence. And I can tell you from my experience representing clients that a lot of the people that we're talking about who don't report episodes of domestic or sexual violence are people who themselves have had negative interactions with the law enforcement, with the courts, and therefore don't want anything to do with that. So I've had clients myself who have disclosed to me that they have been sexually or domestically abused, but do not want that reported to the police, do not want that reported to anyone, because they frankly, being clients of mine almost guarantees that you've had some negative experience with the justice system. And so from our perspective, this is a tool that is there to serve victims that currently are just simply not being served by the criminal justice system, and that won't be served by the criminal justice system because they don't trust the criminal justice system. And there's many other reasons for people not to report sexual and domestic violence. That's just one of the ones that really speaks to or is really reflected in the clientele that I work with. And so because of that, we're very supportive of this. We're also very supportive of this bill because of how it came about. The idea of using restorative justice practices in sexual and domestic violence cases is not a new idea. It's actually been, discussed for years and years, but in terms of it turning into a regular practice, that is a sort of a newer thing. And it's important to us that this was really developed, this wasn't the Defender General's office coming in and saying, hey, we think that we should have some alternative route for cases of sexual and domestic violence. This was really something that came out of the victims community. This was the network provider programs and the CJCs coming together to say, we want to have this tool available to us. And so we think that's really important too, because if there's anybody who knows how to do this in a manner that's ethical, that's responsible, and that protects victims in the process, it's going to be the CJCs and the network affiliated programs. So we've been really comfortable with the fact that that's sort of the origin of the bill, and we're very supportive of the purposes behind it.
Thank you. One quick question for you is, do you think this is something that would help alleviate the court backlogs? Not in its entirety, but one step.
I'd love to be able to say yes, because I'd love to be able to say that I'd love to be able to come up with things that are going to alleviate the court backlogs. I think it's doubtful. I think that this is something that will be used for some very important cases, but also it's not going to be something that's used extraordinarily frequently. I would doubt that it would be something that would be used so frequently that it would actually alleviate the backlogs. And in addition, there's been a lot of talk, and I think it'll be sort of as the MOUs develop to see what the procedures are going to be, that, how these cases progress. But I can imagine in a lot of cases that there will actually be parallel proceedings, that there will be both a court proceeding going on and the CJC proceeding going on at the same time. Additionally, there's been some testimony suggesting that one of the most important uses of this process may be to address sexual and domestic violence that's not prosecutable because either it happened so long ago that it is beyond the statute of limitations, or because just for some other reason, it's not prosecutable, the evidence is not there to be able to engage in a formal criminal prosecution, but yet there is still harm that could be repaired through this process. So, in those regards, I would say no, it's probably not a solution to the court backlog problem. I think this is a solution to a bunch of other problems, just not that one.
Gotcha. Thank you.
I have a question, but it might be for Rachel, not Marshall, and that is whether, and you may also not be able to answer it, but do our community justice centers have the capacity to take on this additional work?
Is it okay to answer for me? Yeah, I would say right now, no, it's a mixed bag. Additional funding would absolutely be necessary. Many of our centers don't have dedicated victim services, and as Jen mentioned, that's going to be an essential piece of this work. So like I said, this is kind of a baby step on a journey of exploring the models, applying for funding, looking at ways that we can grow in capacity to, I feel like it needs dedicated teams. And so currently the short answer would be no, although for some CJCs, they might say, yes, we do, but in terms of like the staffing, but I think additional training would be necessary for all.
Thank you. And I want to be clear, I'm absolutely supportive of this, but I want to make sure that we're setting up a program for success and not doing what so frequently happens where we create something, don't adequately fund it, and then scratch our heads wondering why it failed.
My sense of that is that we're kind of at this catch-22 position of you can't apply for the funding and grow anything without the removal of the prohibition or making the exception to the prohibition. So again, this is kind of one step to move ahead.
And if I can tag on to that answer, I would also just sort of reiterate that that's part of where, that's a concern of ours whenever there's a new program, because we've seen so many programs sort of get funded as pilots, never really get resourced enough to get off the ground, and then essentially be declared failures, even though they might have actually been a really sound idea. They were just never adequately resourced. And it's part of the reason that we support this bill is because it's so sort of grassroots and organic, that this is, these programs will only develop as the CJCs and the network programs collaborate with the, oversight of the AG's office, collaborate, develop memorandums of understanding. And we have a lot of confidence in those organizations that they are not going to put together programs that are going to fail. I mean, we've seen, through our work over the years, working directly with network programs and CJCs, we've developed a lot of trust in their capabilities and in their essentially devotion to getting these types of programs right. And that's part of the reason why we are happy to support it. Even though this is a sort of an evolutionary process, this first step in the process really just removes barriers that prevent these programs from even being explored at this point.
Thank you.
Awesome. Thank you. That's really helpful. I think this is an incredibly important model. And I think especially when you look at some of the numbers around domestic and sexual violence, I mean, I think the last time I looked at a statistic, it was like 1 in 4 people actually reported. And I think avenues like this may cause more people to seek to repair that harm. And there may be a lot more take up in something like this. As you pointed out, there are a lot of people who don't report due to the fact that they don't trust the criminal justice system. And that may be because they're involved, but it may also simply be because of the horrific way we've sometimes seen victims treated in the criminal justice system. So I think that this avenue may well have a lot more people that want to engage with it than we're expecting.
Thanks for testifying impromptu. I appreciate that.
No problem. Thank the committee very much.
All right, so we have, I don't think we have any more witnesses. So we have H 148 at 10:15, so we can take a half-hour break.